This conference will now be recorded.
Okay. Like to call the,
They're driving me crazy with all these spreadsheets.
ladies and gentlemen, I'd like to call.
Have you got your arms around
Hello.
budgeting?
Hello. I'd like to call the July 14th, 2022 Pelican Preserve Advisory Committee meeting to order. Should be on.
I can
Yeah.
hear you. I can hear you.
I'd like to call the July 14th meeting to order. We have a quorum, President Randy Bottleson, Carol Pankow, Mark Eversman. I'm Phil Measy, Ellen Steinbeck. We have Doug Zanter online, and I don't know that John Greggett is online yet. Doug, can you hear us?
Yes, I can hear you.
Okay. I'd like to ask everybody if you have any comments to be made, that you, people in the audience, that you come up to the lectern and identify yourself and your neighborhood. Also ask that your cell phones be turned off. So we have a quorum. I would like a motion to allow participation by Doug Zanter in the meeting because of extenuating circumstances. I guess we now have to say that.
So moved.
Moved, Carol moves. Do we have a second?
Second.
Second, Mark seconds it. Any discussion? If not, all in favor?
Aye.
Aye. Okay, it passes 5-0. The next thing we have on the agenda is our distinguished council. Tony, if you'd like to come up here, there's an open seat. Tony Pierce, who is going to give us a
Thank you.
sunshine law training.
Thank you.
Yeah, okay, and it's particularly appropriate that you be here today because we have issues
I
that,
understand there's some questions,
right.
some other items. I understand that. Afternoon, everybody. And there's gentlemen. That was before, good to see you guys again, yes. And so. This is,
Muting everybody. Okay, there you go.
and hopefully the people who are watching remotely can also see the screen. Is it possible to reduce it a touch? Georgia, to fit the screen without the boxes, or could we maybe
I
do
can,
a little Hollywood squares?
how's
Make
that?
them smaller. There you go. Thank you. Thank you much. And if I misoperate this little device,
Should work.
bear with. Our law firm is the district counsel for the CDD, and we prepared a PowerPoint presentation on the government and sunshine law. The government and sunshine law. I'll reference this. This is the manual. You've probably all seen it online. I'll talk about it later. It's a couple hundred pages that's put together by the Attorney General's office with the Florida First Amendment Foundation. So we'll go through this. This is sort of the introduction.
On the right?
Oh, right. There we go.
Does that work?
Maybe Scott's magnetic personality is in the way. It says it's on.
It wasn't.
Oh, you didn't do better?
No, it was working fine. Of course, it's not. It'll give us a hard time. All right, let's.
There we go. Am I doing? Oh, yep.
Okay, there you go.
Thank you.
Okay,
All right, thank you very much, George, appreciate it. First is, it's very important from the standpoint of the members of the advisory committee, and this is the same guidance that we provide to our governmental clients, their boards or commissions. We represent 7 community development districts, Everglades City, and at times we represent other special districts and local governments. On an as-need basis, represent constitutional officers, but they are separate entities. So whenever there's a question, important, call us, contact us. If you don't have our cell phone number or emails, we'll provide those to you. Our guidance always is, if you have any questions, feel free to call, text us, and then give us a call. And as opposed to listening to peers, friends, or other attorneys, they don't represent you. So, we're the ones that represent you. We're the ones whose opinion and guidance and advice we're responsible for. And I don't know if that can read. An important feature of the Florida law is the Sunshine Law. And this is just sort of a little cartoon that talks about, members of the press. It says another newly elected official hasn't a clue about open government laws, watching this new elected officials, and I can't wait to do the public business, separate balloon. Let's discuss this in private. And one of my favorite examples of that mindset, years ago in the city of Marco Island, I was lobbying council members for a variance on a zoning matter for a client. And this goes back over 10 years ago, and I was meeting individually with the city council members. And as I was leaving the meeting with one council member, he said, Tony, have you met with some of the other councilors? I said, yes, I have. He said, what did they tell you? I said, I can't tell you. He says, yeah, you can. Everybody else does. I said, well, I've met everybody else. I'm not going to tell you. He says, you sure? I go, no, I can't. And I said, I can't do that. So as much as people say they understand, at times they will try to take actions that run contrary to it. It's an overview of Florida's government and Sunshine Law. The Sunshine Law provides a constitutional and statutory right of notice of and access to governmental proceedings of public boards or commissions at both the state and local levels in Florida. Does not apply to the federal government, and also does not, as you'll see later on, does not apply to the judiciary, the courts, and generally does not apply to the Florida legislature. They have certain other rules, but not the Sunshine Law per se. So it's in the Florida Constitution, which is always noted, it's sort of the top of the pyramid as far as all laws that flow underneath that. All laws have to be consistent with or implement the Constitution. So it's Article 1, Section 24B, and it says all meetings of any collegial public body of the executive branch of state government or any collegial public body of a county, municipality, school district, or special district at which official acts are to be taken or at which public business of such body is to be transacted or discussed shall be open and noticed to the public. And then it says the legislature has a separate section, as you notice, except with respect to meetings exempted pursuant to this section or specifically closed by this Constitution. So that sets the table for the Sunshine Law. Implementing that, the Florida legislature has implemented portions of the constitutional amendment. And again, the constitutional amendment was voted on by the people of the state of Florida many years ago. So section 286.011 Florida statute says all meetings, again, the term meetings, of any board or commission of any state agency or authority, or of any agency or authority of any county, municipal corporation, or political subdivision, municipal corporations or cities, except as otherwise provided in the Constitution. And then it talks, are declared to be public meetings open to the public at all time. No resolution, rule, or formal action shall be considered binding, except as taken or made at such meeting, and that the entity must provide reasonable notice of such meetings. And so that's the general thing. And just going off to the side for just a moment, that's the statutory requirement, reasonable notice. The legislature has adopted and implemented specific notice requirements that are different than reasonable. It has specific timeframes. And for sometimes cities, counties, CDDs, special districts, dependent districts, independent districts. So that's the framework is reasonable, but there might be a specific set of notice requirements and timeframes outlined in the statutes. And then after a meeting, the minutes have to be properly recorded. Properly is not defined, but obviously you can't wait a couple of years. and records shall be open to the public inspection. Now, when it says promptly recorded, it doesn't mean tape recorded. It means recorded that they have written minutes, and then they're recorded with the clerk, custodian of records, manager, however you want to designate the individual that maintains the proceedings of that entity. The form of minutes aren't outlined as to what's required. Obviously, everything from verbatim transcripts, that's what Collier County does, to, I'll call it summary minutes, where it says, action item, vote to approve contract with SBA Inc. Motion made by Mr. Smith, second by Ms. Jones, approved, 3-2. I mean, that's summary minutes, and you see a variation in between, sort of what Gateway has. It's the in-between type. But, you know, again, some have verbatim minutes, so you get the whole, every word of the meeting. So 3 basic requirements. All meetings of public boards or commissions must be open to the public. Reasonable notice of the meetings must be given. Minutes of the meetings must be taken and promptly recorded. So the scope of that, what is a meeting? Basically, if 2 or more members from the same board or commission convene to discuss some matter, which will foreseeably come before that board or commission for action, then the Sunshine Law applies. So we take the approach, a conservative approach, that any action you take today will foreseeably come before you in the future. Everything goes in cycles. You know, you discuss an item today, I can bet you $1 it's going to come back up within a year, 2 years, 3 years, 4 years, 5 years. Either people have additional concerns or continuing concerns about the item, or there's further discussion or debate about an item. So our guidance is to all the governmental bodies we represent that if you have taken action on an item, you do not feel free to talk about that item after that meeting, because that may come back before you get, it's foreseeably come before the board or commission. So we take the approach of, even though you've talked about something 2 years ago, don't talk about it today, because next year it may come back, next week it may come back. Again, that's a very conservative approach. There's nothing in the case law or Attorney General's opinions that we found that really require that, but that's our guidance and advice to make sure there is not an issue. So the issue is 2 or more members convene to discuss some matter. So what does that mean? Again, we go back to the statutory provision. Any board or commission is what the type of boards that this applies to elected and appointed boards, including advisory boards with recommendatory that have the ability to make recommendations, such as this committee, planning commissions, planning boards. They are subject to the Sunshine Law. The next part applies to community development district, the board's elected, even though the committees are appointed. Another one, city tourism boards, advisory, that's also subject to the Sunshine Law. There are tourist development councils, they're subject to the Sunshine Law. So the scope, what's generally outside the scope of the Sunshine Law? Board created fact-finding committees or groups, and we've been had a good educational process lately, much more awareness about the parameters for that recently. Staff committees were not delegated decision-making authority as opposed to fact-finding, investigatory actions, or information gathering. Private organizations generally, however, there's an Attorney General's opinion, maybe some case law, that says if you are a private corporation, even if you're a nonprofit corporation, if you've been delegated any of the public entities' governmental functions, or been delegated any of their authority, or an integral part of the public entity's decision-making process, that corporation, nonprofit association, HOA, property owners association, may be subject to the Sunshine Law, as well as the public records law. So that's depending on how much authority is provided to that private organization, they may be subject to the Sunshine Law. Another generally outside the scope is the state judiciary, as I mentioned, and the state legislature. They have a separate section in the Florida Constitution. Members elect or incumbent candidates. A member elect is someone who's run for the board and has won the election or is unopposed. And then incumbent candidates. As to members elect, if they're a current board member or a member elect, they can't. So the member elect who's an incumbent candidate is subject to the Sunshine Law. Non-incumbent candidates who are members elect are not, because they don't take office until the day outlined in the statutes. Different boards and committees. The Sunshine Law does not apply if the officials are members of different entities or different committees of an entity, unless one of the officials has been delegated power to act on behalf of his or her entity or committee. board member talking to a committee member, committee member talking to the Stony Brook Advisory Committee. Those are not members of the same board or commission. So that's not a sunshine law issue. Again, unless you've been delegated power to act on behalf of the committee. Meeting with staff, sunshine law does not apply to meetings with staff unless the staff is being used as a liaison between board or committee members. And this gets into later on, we talk about meetings, it's called daisy chaining, and that can't be done. The courts have said, and Attorney General has opined, you cannot do indirectly what you can't do directly. So example, if I was to talk to Phil about something and he was to tell me something, I can't go to you and say, oh, I just met with Phil and Phil said, that's daisy chaining. And so doing indirectly what we cannot do directly. So the staff is very aware of that ability. The staff can meet with all the committee members, listen to what they have to say, but cannot convey or communicate outside a public meeting what occurred or what the other committee members said. Gets back to what I was saying about that council member on Marco. So what did the other council members tell you? And that's when I said, no, I can't. Delegation. Delegation doesn't avoid the sunshine law. In other words, if authority for final action is delegated to an individual, then there might be sunshine law implications. It's all, again, depending upon the facts of the situation. What types of meetings? What's considered a meeting? Typically, you have a concept of a meeting is you're here, you're meeting. Or if you meet remotely, video conferencing, or you meet by a conference call. The meeting is defined in the sunshine law, is construed by the courts as much broader than that, much broader. And we'll get into that in a little bit, but it can be text communications that constitutes a meeting. Email communications between board members is a meeting. Telephone calls obviously are meetings. Interaction on social media between board members on an item involving the governmental body's interests is a meeting. That's Zach Lombardo. Zach, who's running late. Usually I'm the one that's late. So I will call him out. Zach's an attorney in our office. Zach works with myself and Lenore on local government matters. Zach's handles most of our work for Everglades City, which even though it's a population of what, 600 in Everglades City? Okay, 450, so I'm not mistaken. It has the same issues as any large municipality, only at a different scale, but it's same issues. And they have a sewer plant down there, and it's always kind of fun when you have a sewer plant that's a metal sewer plant in the middle of a national park that's surrounded by salt water. So that's what Everglades City has, and Zach deals with all kinds of salt problems, erosion problems. So with regards to the meetings, again, interaction on social media. That's why I advise my board members to not participate in like Facebook or Instagram or any of those where you can have or community forums like Nextdoor, which I found out from one of my other districts is probably the most phenomenal gossip site in the whole world as far as misinformation. That just is amazing. I'd say please avoid and do not join or participate in those because you may inadvertently respond to another committee member or board member, and that's a sunshine law issue. Okay, meetings of other boards or committees when you're a visitor. No, it's not an issue. It's not a problem. Unless there are two or more officials of the same board or committee and there's interaction should be noticed. And if you notice, no pun intended, in the agenda packets for every board of supervisors meeting, there's a page that outlines the agenda and also says two or more members of the committees established by the board may be present at the board meeting. And we've done that to let the public know that that's noticed, that there may be two or more, they may be interacting, so that they may be interacting at a noticed public meeting. So that's why we have that in there. And that's why I talk about should be noticed. So our meetings between meetings of other boards or committees when you are a member. No, again, if you were to, two of you show up at a Stony Brook Advisory Committee meeting, if you sit there and don't interact with each other, and then there is not an issue. You can sit there and listen and participate to the extent you don't interact with each other. Same with, again, we've noticed that for the board of supervisors meetings because there might be interaction. That's why we noticed that. Community forums, again, no, generally, unless there are two or more officials of the same board or committee and there's interaction or discussing issues that may reasonably be expected to come before the board. So if you have a big gathering of the residents of Pelican Reserve, you're there, you're a resident of the community, you can't interact with any other committee member at that meeting unless it has been noticed as a public meeting and someone is there to take minutes and record those minutes thereafter. And that's important. And then we get into another issue with regards to meetings. So what type of activities are prohibited meetings? As I mentioned, emails, text messages, other written communications to, from, and among board members. And memos might be if they elicits a response or they request a response. One-way memos may be okay at times, but we're always very careful about one-way memos, where it's just, I'm going to bring a topic up for discussion. We always recommend that they go to the staff person handling the committee, and the staff person then either distributes that and say don't respond, or puts them in the agenda pack. So the committee sees, that way there's no interaction. Because the temptation is to reply, and it's not appropriate. One other issue too is when someone sends an email out, a one-way communication, people may reply to all inadvertently. And so that creates an opportunity for issues. So that's why we recommend, if you're going to communicate to other board committee members, do it like a memo to the staff person, ask them to put it in the next agenda pack. Social media posts is, again, I said, with responses or interaction. Again, they constitute meetings under the Sunshine Law. Fact-finding trips by the governing board. Interestingly enough, the Board of Supervisors cannot make fact-finding trips. You all can as a committee, fact-finding, but the board cannot. Private discussions concerning district matters during recess, that can't take place. So whenever the recess is called, you can't sit there and talk amongst each other about, what did you see John came up there? What do you think of, you can't do that. That all has to be on the record so that the public sees what's going on and hears what's going on. Inaudible discussions between board and committee members that public cannot hear, again, that's inappropriate. That cannot take place. I mentioned the Sebastian City Council. There's an article below, but also there's a web link. Sort of advancing where I'm going to be talking about that group. Sebastian City Council about a year and a half ago decided they didn't like the city manager and the city attorney and some other staff. So some committee council members decided they were going to, at a city council meeting, usher everybody out, call a recess, usher everybody out, lock the doors to City Hall, then conducted the meeting and fired the city manager and fired the city attorney. Okay, but before that, they had all these little sidebar discussions. A number of those council members were charged with, violating the Sunshine Law, and a couple were charged with perjury because they lied during the investigation. So but inaudible discussions can't take place, and you can't lock out the public and take action. What other meetings are covered and must be open? Absent specific exemptions, workshops, yes. Investigative meetings, yes. Attorney board meetings, generally yes, but there is an exception, and you've probably seen the notices for those. For closed door attorney board sessions, we sometimes call it shade meetings. I don't like that term, but others in our office do. He's a big fan of that term, and so is my partner Lenore, and some other attorneys are. I just prefer to call them what the statute says, closed door meetings. And there's a specific exception in the statutes for that, and you have to follow protocol. Some other exemptions from public meetings as far as being open to the public. And this first one happened after 9/11. That portion of a meeting that would reveal a security or fire safety system plan or portion made confidential and exempt. After 9/11, there was concern about infrastructure being targeted because plans for utility plants, utility lines, water lines, sewer lines, power lines, communication lines, were all out there for the whole world to see. You could go down to your local utility department of a county or city and say, can I see the plans for the subdivision? And they were public records and they had to be shown. And so there's an exemption in the public records law for those. And they also created an exemption regarding meetings when you talk about certain matters like security or fire safety. For example, a discussion of the Board of Supervisors about where to place cameras around this building. That portion, you can usher the public out. We have to take minutes, but they're sealed after that portion. Another section that makes certain portions of our meeting, any portion of our meeting in which a negotiation with the vendor is conducted pursuant to competitive solicitation. When the vendor makes an oral presentation, it's part of a competitive solicitation or answers questions. So that can be, they're not required to be closed, but they can be closed. The closed door meetings, the attorney privilege communications, it's limited to pending litigation, not open to the public. It's not foreseeable litigation, threatened litigation, it's only pending litigation. So a lawsuit has to be filed or an administrative proceeding pending. If the district were to challenge, for example, a South Florida Water Management District permit, that's a pending litigation. The district sues or gets sued, that's pending litigation. the district talking about suing somebody or talking about being sued is not pending litigation. So that's very difficult at times to give guidance to local government when you know you're about to be sued or you know you want to talk about suing somebody. You can't have private closed door sessions. Settlement discussions to resolve the litigation are also part of the closed door strategy sessions related to litigation expenditures. And it's a narrowly construed exemption. The attorney has to call it in advance in reasonable public notice. We have to list who's going to be there. And the courts have said you got to strictly follow the rules on that. The entire session, you've got a court reporter. The court reporter transcribes everything, and then that transcript is sealed until the end of the litigation. And again, these are very limited number of people that can attend. The board, the attorneys, chief administrative officer, the court reporter. You cannot have any other staff there. So, and I told my board, so if you have a closed door session, you cannot leave and come back because then it makes it open to the public. So it's a very interesting process. Again, notice and procedure, just generally. Notice and agenda. This is just, again, another little cartoon. You have this committee. There's all those in favor of what we discussed in our email thread. And Larry's son's birthday party last week, vote aye. And then the public is I have no idea what's going on. It says, I thought the meetings were open. So the whole idea is notice and agenda. Notice and procedure. Reasonable notice generally required. And specific notice as to community development districts required by that section 189.015 Florida statutes. The statutes allow a community development district to publish either annually, quarterly, or monthly the meetings up for the upcoming year. If there's a special meeting called in between that time, and this district, like other districts, publishes an annual notice of meetings. Then there has to be a notice in the paper for additional meetings 7 days in advance of the meeting. And then there has to be an agenda. It's not required by the Sunshine Law, but as to community development districts, it's required under a separate statute. And the agenda has to be posted on the website at least 7 days before each meeting. Now, a couple of years ago, the legislature decided to make a requirement that 7 days in advance of the meeting, all the written materials that you planned on having at the meeting needed to be posted online. They removed that in the last couple of years, and I think it's a product of all those lawsuits for ADA lawsuits, which I don't know if you heard about. This district got sued along with others, where a woman was going around the state of Florida. She filed over 100 lawsuits in federal district courts all around the state, saying, I tried to gain access, I'm blind, I tried to gain access to documents, public records, and meeting agendas and documents of this community development district. The materials were not ADA compliant, so I'm suing you. And that litigation, again, I think the legislature decided this is kind of over the top. It resulted in a number of community development districts taking documents off their website, because what they would have had to do is convert their documents to an ADA compliant format, which a PDF would cost $1.50 per page to convert. So if you recall years ago, you used to be able to go online here and get everything. And a lot of my CDDs, the same thing. But now they've cut back because of that. But then, so notice and procedure, you have to have an agenda. Now, the agenda can be modified and amended at the board meeting. So you may have an agenda, and items may come up between the time of posting of the agenda and the board meeting, but the board can amend the agenda at the time of the meeting. Location. Again, this is part of the Sunshine Law. Facilities that discriminate or unreasonably restrict access or prohibit is meeting locations. For example, if you anticipate a large crowd, you need to accommodate a larger venue. If you have a small room that holds 20 people, you know that 500 are going to show up, you have to make accommodations for a larger facility. Otherwise, you're having a meeting that's improper under the Sunshine Law. And again, an additional requirement for CDDs, the meetings have to be held in a public building when available, in a county courthouse, in the district, or in a building in the county, it has to be accessible to the public. So that's another requirement specific for community development districts. What if a person or board member or committee member can't attend a meeting? The Attorney General has some opinions, and local government attorneys have provided guidance that can generally appear telephonically or by video if there are extraordinary circumstances and a quorum is physically established. That's the key. We've gone through this with COVID. A quorum is physically established, and the members who are present physically allow full participation by those calling in the vote. But the key is it has to be physically established a quorum. Minutes, Again, part of the Sunshine Law must be promptly recorded. Either verbatim account or summaries we talked must be available for public inspection. The failure to comply with the Sunshine Law. Criminal penalties at times, removal from office, non-criminal charges, attorney's fees, and a civil action for injunctive or declaratory relief. And here's an example. The newspapers love to put local officials on the front page of the paper. This is the former mayor of Cape Coral. Back in October 2020, he pled no contest to Sunshine Law violation. In this case, though, he was talking with another council member about an appointment of someone who we knew to a particular position. So there was another council member. They talked outside the board council meeting. These are some examples, and I have a PowerPoint. You can go to these articles about violations of the Sunshine Law, where the public has been made very much aware by the media. Failure to comply, what happens? The invalidity of action, arguably. The courts have said if you violate the Sunshine Law, any action taken is void ab initio, that is from the beginning. And contracts are void. There is a remedy, though. And the remedy is independently take final action of publicly noticed meeting in the sunshine. In other words, but the boards or commissions cannot rubber stamp prior action. In other words, if there is an allegation that's founded that action taken by a governmental body was contrary to the Sunshine Law, awarding a $80 million contract, say, to build a sewer plant. It's almost to challenge that, and the court said it's invalid, or in the pendency of the litigation, the governmental body says, okay, we will bring this back to the full city council, full county commission, and have a full-blown public hearing, notice everywhere, pros and cons, analysis, reports by staff, by consultants, even your consultants, and we'll have a full, robust discussion of it. And that can, at times, correct the action for which was found to have a problem. So these are some resources for general information. If you want to look up your own, but again, always feel free to call us. And there's Sunshine Week, every year we have that. And the idea is that for shady government, the sunshine is supposed to be the best antiseptic, and the shady government doesn't like it. If you have any questions, I'm sure you have a few.
Tony, on the amending the agenda, does that have to be, does someone formally have to say, I want to amend the agenda, or cannot, for instance, could I, as a chairman, say, I'm going to add this item to the agenda?
In my opinion, the committee as a whole should approve the amendment to the agenda.
Amendment to the agenda.
Yeah, that's the typical format.
Mm-hmm.
And you may want to, I don't have your agenda here. And I always tell people I get smarter as I go along, learning from other attorneys, other governmental bodies, court cases, and attorney general's opinions, that at the beginning of the meeting, after call to order, establishing quorum, pledge of allegiance, is consideration of amending agenda.
Mm-hmm.
The board may want it, or setting the agenda. That's one way to do it, setting or amending agenda.
Mm-hmm.
So you confirm it, or you rearrange items on the agenda, or you formally amend it. I think that's a better practice.
Mm-hmm. A lot of our interactions occur via staff here. Somebody has something that they want to put on the agenda. We send it to Georgia, and she puts it on the agenda. And any individual can do that, or we allow any individual to do that. The question is, I think mine is it, can you just put information on there, or could you put on, here's what's going to be on the agenda, and by the way, I'm going to vote yes?
No, you can't do that.
Okay.
No.
Yeah. So in other words, no opinions, just facts, if you will.
Here's an item I wish to have discussed at the next board
Mhm.
committee meeting.
Yep.
Yeah. Did you drop something?
No, I never.
That was a subtle way to get my attention.
I'm around it, sorry.
Okay. Well, that's a good way to get my attention. Thank you, Paul, I'm sorry.
Yeah, that's all right. Randy, you indicated that you had,
Tony, I act as a liaison to a safety and security work group. I am not the chairman, but from time to time I have attended meetings for them. And I have also gone to our President's Council, which incorporates all the neighborhoods of Pelican Preserve, to either discuss what safety and security has been talking about or take questions. So I guess my question is, can I continue to be going to their meetings? Or what?
When you, I guess, two parts, and Jack may want to step in also. From the standpoint of the safety and security group, you just sit there and listen to what they say as far as their observations and the fact.
Yes.
You don't provide any input or suggestions or anything you learned from.
How can you not?
Well, I guess.
I mean, it's my understanding that I was to, bring forward issues to this group for discussion, and or if there's some action to be taken, perhaps put together a motion for expending money for a CDD workshop.
I think from the standpoint, you sit there and listen to what they've observed. In other words, the security safety work group said, we noticed that the hours of operation are such and such, or that the access control post orders say so and so. And those are, and those, we've noticed long lines because of it. We've noticed this, we've noticed that. Then you may have an idea as to what you want to bring to this committee, to make recommendations for actions from a security or safety standpoint. Is that what are you envision your role? If you can wait a second, don't please.
Sure.
No, I appreciate it. Well, I'm not going to ignore you guys, trust me.
Just kind of an,
And as far as the President's Council meeting,
yes,
how
that
many
was
of
my
you
next
attend the
question.
President's
That
Council?
was my next
How many of
question.
you attend the President's Council?
I virtually always do. And other people now and again, for instance, Randy, we've requested Randy to come in or Doug Santer to come in and give a report of their work group. So we've done that.
When the report's provided, is there any interaction between the other committee members that are at that time, or it's just a report?
It's a report generally with questions from other members of the President's Council.
Or not other members of this committee?
No, it's
Okay, so
probably,
the-
it's
so there's no
probably
interaction.
happened. As long as there's not, the other members of the committee aren't, I guess I'm hearing you say, don't participate, then you're okay.
Don't interact, don't participate.
Don't, yeah.
In other words, Randy will field questions and just on his report,
Mhm.
but no one else on this committee that's present can say, well, no, what Randy meant was, or Randy don't, or
Okay.
no interaction. Or somebody say, Phil, what do you think? You gotta say, come to the committee meetings.
Mhm. Other questions?
Does that help? Well,
Carol, yeah, go ahead.
Yeah.
Um,
I'm sorry.
Do you have a card, or can you give me your email address? I have some unique positions I'm finding myself in.
Okay.
And so I would like to email you and ask you some questions rather than do it verbally, because I know attorneys oftentimes don't like to be hit with stuff. And it's kind of, it's an interesting combination.
What I've suggested is I'll leave my phone number, it's my cell phone number and office number. And
Okay.
easier to reach me by my cell phone number.
Okay,
Then give me a call and we can have an initial conversation about it. How's that?
okay.
And I'll do
Did
that
you want to
before
give
leave.
that to me now, or?
Oh, yeah, that's, well, everybody knows.
Hey,
Yeah, it's
hey,
Tuesday.
Tony, this is Doug Zander. I'm a little different than Randy because I am the chairman of the Ponds Group. We meet together once a quarter at a specific time. The same, I think it's the second Thursday, once a quarter. And we meet together as a group. I call it fact finding. Recommendations of the group come to me, and then I recommend to PPAC. And then PPAC either does, either takes that recommendation and then they go to CDD board for approval, because the work group or the PPAC do not approve any of those things. They just go to CDD board for approval. Do you see any issue with that? I'm just trying to refine maybe how the group works, but I just want your thought on that.
Now, we've had some clarification and adjustment to, after further discussions and review in the last couple of weeks or months. And from the standpoint of you meeting with the work group and them advising and reporting to you of facts, their observations, then you can compile that and then bring your recommendations to PPAC at a public meeting. But
Correct.
that work group is not to make any recommendations. In other words, if the landscape work group or ponds work group said, we noticed aerator on Lake 29 is not functioning, or we have a report by Mr. Jones that the aerator on Lake 87 is noisier than all get out, or someone else says, hey, there are 4 palm trees that are dying over in, let's say over in Palazzo. Those are facts that the committee would then provide to you. And then you would come to the committee, the Pelican Reserve Advisory Committee, and make recommendations, say, this is what's been reported to me. This is the format the board approved at its last meeting with regards to the work groups. So that's a further refinement, Doug.
Okay. But some of your examples is the thing is an aerator not working. I have a application almost like a Meriscape that we report to our ongoing maintenance vendor. Every aerator that's not working is reported that way. I don't go forward to the board for every aerator that's not working.
Understood. And I guess part of the process we talked about was that I think Scott also would be in that loop as far as getting a copy of those observations. That's my recollection now. I think I don't have the outline in front of me. No? Okay.
For landscape, yeah.
For
For
landscaping.
landscaping is right now because we've just establishing the rules for
The newer
landscape.
parameters. Those same parameters apply to all work.
Mhm.
But we do have a problem tracking system that we don't, personally contact the contractor. It's reported to an application that routes it to the correct person.
Okay, and again, the key issue is that the work group, Doug, of which you are part, just reports to you their observations or the tickets or whatever you have.
Right.
Advises you of that, and then they don't make recommendations as to what should be done.
No, in fact, I don't either. We just report. We don't know how it's going to be fixed. That's the vendor, the contractor's responsibility.
Only because I thought you mentioned about the fact that the work group makes recommendation to you. So if that's not what happens, I just want to make sure.
Yes, it happens all the time.
Okay, that
Yeah.
part of what we've addressed in the protocol that the board adopted this last meeting is that the work groups don't make recommendations, and they observe and report. That's it. And
Right.
then
Okay.
the chair,
I'm clear.
the chair of the particular work group will then come to the PPAC at its meeting and say, here's the information I've gotten, or the information that's been provided by members of the work group to the vendor. Here's what we recommend, or PPAC, what you recommend that we do.
Except I'm interested just drilling down a little bit on the specific example that Doug gave. If they have right now a situation where if one of something goes out, it's automatically reported to the vendor. Is that right, Doug?
It's automatically reported through the trouble tickets system. I'll be honest, this is not honest. The individual residents report a lot of that stuff where they will call me and say the aerator on this pond is not working, and it's just put into the trouble ticket system. I mean, we do summary, but I mean, we're talking about, 40 or 50 issues, trouble tickets per month. I don't know if we're going to go through every one of them at the PPAC board meeting.
Can you repeat that for Tony?
I was going to say there's 40 or 50 trouble tickets every month. I don't know if we want to go through those 40 to 50 I'm going to just call them trouble tickets in the detail underneath each one. We would take the entire meeting just to do that.
Well, I guess to the extent that those are reported directly to the vendor, then the vendor takes appropriate action.
That's
Correct.
That's
Correct.
okay.
And And the vendor is the one that takes the appropriate action. We don't tell them what to do. I mean, a lot of times we might not even know what to do because it's a yearly contract they're on to do the maintenance on all of their aerators or other things. These are yearly contracts with our vendors.
So this is merely either reporting directly to the vendor or you providing to the vendor a report from a resident that this aerator is not working. Or
Yes.
the tree is dead, or the bougainvillea are dying, observations. Okay,
Right.
that's fine.
Okay.
Because again, you're not, I'm sorry? Oh, no, okay. Because then you're not making any recommendations. It's just the vendor, it's up to the vendor as the contractor who has obligations under the contract.
Right. His obligation is to fix that broken aerator, whatever the problem is.
And address it in the manner in which the contractor is independent.
Right.
Contractor, using
Correct.
their independent judgment based upon the contract parameters,
And we are not charged additional for that.
which is a good thing. But that's fine. Zach, any you anything to add to that?
I'm fine with that.
Well, if the vendors have any questions, they'll go to staff. Generally.
And whose staff will they go to, Doug?
What?
If the
I
vendor,
didn't hear that question.
if the vendor has a question, what staff will they go to for?
A lot of these contracts are done through CDD. Most of the time, L is the individual that works with us as we go through bid process all the way through contracts and stuff like that. L fields a lot of those.
Okay,
That's
so it's CDD staff. In the
Yes.
case,
who's
the
administering the
landscape-
contract.
in terms of, for the landscape work group, we're talking about Castle staff, EPCA staff.
Okay, and that's who the vendor would contact.
Mhm.
If there's any
Okay.
questions.
All right.
Bill, you have a question?
Bill,
This is, I'm sorry.
could you come up so we get this?
Thanks. Bill Sirico from Pelican Preserve Community Association. I get the central question that we've all been dealing with for the last few months, I guess, and I want to make sure I'm clear. The limitations on the working groups. May they make recommendations, help in the selection of vendors, negotiate contracts, or oversee the work of those vendors after they've been retained? Those are the four questions.
Those are four independent questions. The work groups can report, make observations and report, provide facts. As far as making recommendations of vendors, if they can't make recommendations, but they can be requested to do some investigatory and fact finding on the various vendors as to other areas where they perform work or have contracts, and then report those observations, the results of their investigations, and not making any recommendations. Those are two or three of the questions. Bill, what else?
Along with oversee the work of the vendor or help in negotiation of the contract.
They don't oversee the work that I outlined, just outlined the process. They don't oversee the work. They report and observe, and they put in the tickets if necessary, and or pass on the tickets. And then the vendor needs to address it, and the vendor has any issues, they'll work with the appropriate staff tasked to that particular area. And the work group does not negotiate with the vendor.
The work group does provide specs for the contract.
Yeah, Bob.
Hey, Tony, for us in our group, all vendor negotiated contracts go through Laura and her team with the formal process, the formal bid process.
Yeah, well, I was trying to answer this, Bob Gephardt, trying to answer Bill's question. The work groups do give the specs before a contract is issued. They tell, we're trying to do this, we're trying to cut the grass, so that the staff knows the parameters of what we're looking for by issuing a contract.
Yeah, I get it.
And that's a collaborative process, because let me answer, okay, he'll answer it, but staff is a very much part of it. They all sat in every meeting and helped develop it, and they were giving her additional facts to be considered when a contract is written. As well as Scott, that's how we did the landscape, correct?
So I guess
Is
that's
that
the,
permissible?
no, I get, the question is, I mean, I've not heard that raised as an issue before, to the extent that the members of the work group outline facts that this area does not have an irrigation system, or this area has treatment only 4 times, those kind of factual observations or investigatory results. As far as setting criteria or parameters, the committee and staff can do that. But if the work group is going to do that, it needs to be, you can have a noticed meeting of the work group to do that. And that's how you handle that. Because then you're getting into the recommendatory advisory role. So at those unique times when they're getting together to make recommendations as to specs, have a published meeting. It can be published on the district website. Does not need to be in the newspaper. I agree with that. Understand that?
Yeah, Philip?
Yeah, I was just,
Because that's something I didn't
no,
know.
what I was trying to explain is not what happened in the last meeting when we got new direction. I was giving the historical. Historical was landscaping and ponds. We worked with staff, and it was kind of a joint effort. And if that's inappropriate, it won't happen anymore in the future, obviously. But it was just to try and collaboratively figure out everything that we wanted in the contract. And this has only been done 3 times, as far as I know, when we issued contracts.
Again, it can happen. It's just to be noticed. That's all. So at those unique times when you have the work group, you want to get together for them to help on the specs, just notice the meeting and then have minutes taken.
Philip?
That's the easy way.
Philip Robner from Carina Pelican Preserve. The current landscape contract that exists for the district was principally negotiated by the landscape work group. The landscape work group identified itself as the recipient of all oversight related to the landscape work group. I know you've had some discussion with the district to try to set some actions going forward. The question is, how do we remediate the things that have gone on in the past that haven't been presented to the district and make sure that they don't happen again?
I'm not going to answer an open-ended hypothetical question. I guess I may take issue with some of your characterizations to the extent that all those large contracts and the specifications came before the full Pelican Preserve Advisory Committee. I understand it. They were fully debated and discussed. And as I understand it, also the full specifications and criteria and all those contracts came before the full Board of Supervisors, and there was discussion before they were approved. I think that was, what, 3 years ago, 2 years ago?
I'll make some comments on
Let's hold,
No, I'm trying, no,
let's hold on for a moment
that's my,
here. I mean.
when was the most recent contract that we're talking about?
Landscapes and security.
Yeah. And those were approved by PPAC. They did come before the committee,
And they came before the board.
and they eventually came before the board.
And they were presented by the state.
And if anybody has,
You know, now how thoroughly they were debated, I think is up for grabs.
but there was an opportunity for full discussion.
I think there's been accusations that are not.
Well, Joe, would you please wait? Thank you. Till these questions get
And
answered.
again, we've had some discussions with obviously the various residents and their concerns. We've crafted a process that we provide our guidance we're comfortable with. And as far as the kind of go forward basis with the work group. And so, and again, if there ever is a desire to have recommendations for specifications made by the work group, call a meeting, notice the meeting, and that addresses that.
Joe, you
But
have,
the general meetings where if they get together and just advise the chair as to the issues in the work, no, that fact finding and that reporting of fact finding is not subject to the Sunshine Law.
Joe, you have a comment.
Joe Schofield, I live in Carina. I was involved with the landscape work group. And I would like to confirm that, first of all, the contract that was put together by the CDD. They pulled all the records. They did the historical data. They presented that. They presented it to the landscape work group to get involved with. They asked us to discuss questions and talk to the final contractors that finally submitted bids to the CDD for us to look at. We asked questions. We presented all that in a written document back to the CDD. So they were totally aware of everything that we were doing. And any questions were resolved at that level. We then came to the Pelican Preserve Advisory Committee board meeting, and gave a presentation of all of our findings so that the board could then decide who they wanted to offer a contract to, which they then voted on and sent to the CDD with their recommendation. PPAC did, and the CDD awarded a contract for landscaping through that purpose. So there was nothing that was hidden. There was nothing that was done under the table. Everything was very much open. Everybody was aware of what was being done. And I think Mr. Robner doesn't have all the details or facts. Thank you.
Tony, you taking Joe's description of how that was handled, was it appropriate?
I'd really give legal advice separately, Bill.
Mm-hmm.
No, I mean, again, I don't know all the facts. Again, from the standpoint of all the presentations being made at an open public meeting, that's fine. I mean, again, there was full debate and discussion by the Pelican Preserve Advisory Committee and the board. If anybody wants to challenge the contract, challenge the contract.
Mm-hmm. At this point, particularly with the landscape work group, but it also has to be done with the ponds work group. We envision, and I just want to run this past you, I think the way we envision it working is the landscape work group will make observations of things that need to be done. Mark Eversman as the chairperson of the landscape work group will then formulate recommendations based on those observations and will bring them to the PPAC for approval. Is that an appropriate approach?
That's what we discussed, but I think the presentation should be, at the PPAC meeting.
Yes. Oh, yes,
That he
yes.
makes
Oh,
those
yes.
recommendations at
Yes,
that meeting.
at the meeting. But he would bring them to the meeting.
Yes,
And he would work in conjunction with Scott or now Nick.
but is Scott, any member of the work group? Or not?
No,
Okay.
no, he's a staff member.
Okay.
So he might work with Scott to present some of those things, and that's still appropriate.
I thought he was on one of the work groups or not, or is he a liaison to the work?
Who?
Scott.
No, Scott is not
Okay.
on.
I see. No, I knew
He
he
works for the
worked for it. I
community.
just thought I understood.
He's
that he
a staff member.
Okay.
Okay. So if he's involved in that process, that's okay as well.
With Randy or the chair of each work group. Well, in this case, just one. Work group.
With Mark.
Yeah, I'm fine with that. Jackie, what do you think?
An outside contract.
The contract provides that the agreement between the district and the Pelican Reserve Community Association provides that they provide certain services. So in that respect, he's sort of like a staff because he is a contract vendor, but he's a contract manager under that contract.
Mm-hmm. Okay.
So I consider him comparable to being part of the staff for operation and administration of that contract.
Mm-hmm. Okay. Are there any
You know,
further?
Scott feels like he's not. I know, I'm just being a little facetious, Scott.
Are there further questions by
Yeah,
either?
I want to make sure, I'm new to this, so I just want to make sure I completely understand this, so somebody says I misconstrued what's being done. Right now, Scott and I go out and we identify what we consider to be deficiencies in landscaping together. And we then say, this should be done, in our opinion. We then have to come to this group.
Oh, okay, I guess the important part, are you meeting with Scott as a committee member or are you not in the work group though, right?
I'm a landscape work group chairperson.
Chairperson.
Okay, so you're the chair of that work group?
Right.
Okay. So you and Scott, all the observations, I'm sorry, then you,
We meet, we come up with recommendations as to what we feel should be done. It's my understanding that I then come to this work group and present what we would like to see done, so they can say yes or no and approve funding for it if they agree or disagree. As part of that, I will also come up with some designs as to what I think would enhance the area.
working with Scott on those also?
Scott will see, or Scott or Nick, as you will see whatever recommendations, if that's the correct word or not, I would come up with in order to remedy an area. And again, those would be brought before this group to approve or deny.
In fact, we're going to be doing some of that this afternoon.
Yeah, I'm fine with that, I guess, right? they're not part of it. Work group members, we report either to this gentleman, I'm sorry, I didn't get your name.
Mark.
And he gathers all that, and then he and Scott will go either observe it or evaluate all those. And the other members of the work group don't advise you what they recommend, they're just reporting conditions.
In this particular case, you've
They
been
can give
doing it.
opinions.
Yeah.
No, they can't give opinions, they can just report conditions.
I guess my concern is, all right, landscape design. So in order for me to be, according to the law, I have to do it all. Because I'm not allowed to get anybody else's opinion unless I go out for a contractor.
But they can report conditions that they observe.
I understand that. But they can't give an idea of an appropriate
Solution?
remedy for that.
That's correct, unless they have a public meeting here to tell you about that. And then there are minutes taken of that.
Suppose one of those members came to this meeting with a recommendation. Would that be appropriate?
No, again,
Yeah.
their role is solely fact finding. If it
Mhm.
becomes recommendation, either individual or otherwise, then it makes it more of a blur within would need to have the notice public meetings.
Mhm. Okay, answer your question, Mark?
Not really. I mean,
Can I chime in?
Yeah.
Chelsea O'Reilly, District Manager. Good afternoon. Thank you for coming today. Let's not forget the intent of meetings in these work groups. It's to provide public input. Okay, so that's what we really need to sit back and consider and look at. If it's a work group, if it's PPAC, if it's the Board of Supervisors, the point of having it open in the sunshine is to have the input of the community. So just please keep that in mind as you're working through these discussions.
One of the things that we try to accomplish with the work group is to bring in a number of different skill sets. So we have former police officers who are well suited to talk about safety issues within a community. We have transportation engineers who understand the best way to approach traffic. We do traffic counts, things of that nature. So how can we not count on these types of people who spent a career developing this expertise in not making recommendations? I don't get that.
No,
It
I'm not
doesn't make
saying you
sense to
can't.
me.
You can, if they meet in the public to discuss and make those recommendations.
So what, if they meet, do they all have to come here and meet?
You'd have to have a quorum of that work group in essence, yes.
It makes life a lot more complicated. That's for sure. Because
Hey, Tony, couldn't the landscape group though have an ongoing meeting of the landscape group that's open to the public on certain, I don't know how frequent or something like that? That's a public forum. They can take notes. Isn't that a way to be able to do that?
Yes. They can publish a schedule saying the
Right.
landscape is going to meet every, pick a number, Wednesday at 4 PM at the district office. And it has to be open to the public. They can meet at Pelican. That's correct. They can meet at Pelican. They come to the gates.
Right.
and meet- the public has to be- And then
And
minutes have to be taken and
Yep.
again, and then promptly typed up and filed with the staff. Yes.
right. And Mark, that's what we do in the Ponds Group. We started publishing. We didn't always have that published, but in the last few years, we publish a certain, it's the second Thursday of each a month, once a quarter, and that's when we have our meeting, and it's published.
And those are the only meetings, Doug?
Yes. Those are the only meetings we do, and Scott's invited to that too. Well, it's a open meeting, so anyone can come.
Then the work group can make recommendations.
Okay.
And so the other groups may want to do the same. That's how you resolve it.
Right, it's an easy way to abide by the rule and still get with a lot of expertise can be done in a public forum.
Any further questions? We have somebody else.
I have one more.
Oh, there's somebody else ahead.
Ed Hedges,
Who? I'm sorry.
Ed Hedges at Azure and Pelican. It's just an observation. I'm new. I just moved in a few months ago, but I haven't been able to find out what the different work groups are. I hear these work groups. You know, you've mentioned a safety and a security or something work group today. That's the first I've heard of it. I haven't found anything on the website other than, you know, I've heard about the ponds but who are on these work groups? Who's on them? It's not published anywhere. Their meetings aren't published. They aren't open. We don't have a clue of what's going on. And how are the people put on these work groups? Yeah, those are just questions. You know, I'm new. I'm trying to figure it out, man. It's a cluster, in my opinion.
Okay. Philip, you had a comment?
Yeah, I don't want to beat a dead horse. I think Mark and Doug and Randy have come up with some ideas. They're going to have some public meetings and they've got to be noticed. And that's all a good thing. But what happens in the interim? What happens in between meetings? The current landscape work group designates the PPAC as the contract manager and names one of the former members of the PPAC as the contact person. Now, I don't know whether that's easy to correct, but the fact is it at what point can the the committee members or the PPAC actually oversee a contract and deal directly with the vendors on a regular basis? Because those meetings don't happen once a month, once a quarter, or whatever. I mean, in landscaping, you've got activities that go on every week or maybe even every day. So what's the role of the PPAC member and what's the role of the work group member when those types of things occur between meetings?
And that's something we'll work with Phil and staff on. Address that question. Once I fully understand all the roles.
Mm-hmm. And I think the the comment that we have to be more public about who's on the committees and what they do is appropriate. The names of,
And who they report to. Talk about the work group, but who does it report to? It's not been clear to me, and I've come to several meetings. So.
any further questions or comments? This is a knotty problem. It's been going on for a long time. We have not addressed it, but clearly we need to.
And I think the committee is addressing.
So we're
Having this good open dialogue.
starting to work on it, have dialogue to address it.
Yeah, why don't, this answers this gentleman's question about the work groups and so forth. And I'll make an attempt, and you correct me if I'm wrong. But certain work groups were put together to protect the assets and the people who were in Pelican Preserve during the time that WCI declared bankruptcy. And they're all volunteer and have been looked at in large part dependent on the things of the biggest concern to our community. And I think it's safe to say that that is the security, the front gate, and all the other issues that go along with security in a gated community, and the landscape and infrastructure, which are important to every person within Pelican Preserve. So that is the genesis, to my understanding, behind these volunteer groups looking out for different aspects of Pelican Preserve.
I'd have to amend that explanation a little bit to say that the work groups were set up by the Pelican Preserve Advisory Committee, which is really who was overlooking these things. And the work groups were set up to do work, if you will. In this case, we now know that their work should be observations, if that's what they were set up to do. One of the things I think we're going to have to address is frankly, these work groups, and Tony, I think I sent you a note about this, these work groups really don't have charters. There was no formal establishment of the work groups. And indeed, I don't know that there was a formal establishment of the Pelican Preserve Advisory Committee. And probably,
It was, the board approved the establishment of the Pelican
Advisory Committee, but
Yep.
it really, but did it say what its responsibilities are?
I can look at the minutes.
Yeah.
That's the one because it wasn't very vague. Very vague.
Yeah.
I can answer that.
Yeah.
Well,
Yeah,
I would suggest that a couple things. One is that Doug's group sort of sets the standards
mhm.
for how the other work groups should work. And we'll work with Chelsea and the board to outline some parameters and come back to feedback with some recommendations and then get those recommendations to the full board.
Mhm. I think that would be appropriate. Are there any more questions or comments? Okay. Well, come on up and make your comments.
Joe Schofield, Karina. There was a charter written. It was never endorsed by anybody, but it was written and the name of the PPAC was slightly different. That was done, I have a copy of it, but there was a charter that was proposed. Why it wasn't totally signed off, I have no idea, but there is a charter in writing that exists, which I could certainly forward to anybody interested.
Any other comments? Okay, well, we're going to need to move into a related issue. And that has to do with a memorandum of understanding between, a proposed memorandum of understanding by the Pelican Preserve board on how the Pelican Preserve Community Association Board and the Pelican, really the CDD, will work together with regard to these committees. I sent all of you a copy of this, the memorandum of understanding. And you were given another copy of it right now. And I'd like to get your inputs on this. Carol?
Yeah. I have,
Jeffrey again. There is another version. I would say that both versions are in front of feedback. This one has been vetted and approved by the district's attorney for its language and content to make sure that it conforms to the sunshine law. So when you're concerned.
Phil, this is John Greger. Can I please have the committee vote as me being present? And if you allow me to vote, because I don't think that has been done yet.
No, it has not, John, because you weren't here when we allowed Doug to do it, but I would, since we have extraordinary circumstances with Mr. Grega was not able to make the meeting, I call for somebody to make a motion to include him in the meeting.
so moved.
Carol moves. Can I have a second? Second. Randy, any discussion? All in favor?
Aye.
Aye. Okay, John, you are
I
now.
thank you very much. Appreciate it.
Okay,
Okay, Carol, go
Mr.
ahead.
Chairman?
Yeah.
I have a version of this memorandum that I received from Georgia when she submitted all the documents to us along with the agenda. I have a version from Bob Gebhardt with items that are highlighted. I have another version from Bob Gephardt, version C, which in his email, he said that these were changes that the attorney had seen. And I have a fourth version, D, which is sitting in front of me when I came to the meeting today. And now I have a fifth version that Bob Gephardt just passed out. Could you please tell me which of these 5 versions we're going to talk about? And then we can discuss, please.
We are talking about 2 versions. One was the one that was forwarded to you by Georgia for this meeting.
Okay,
And
that was the very first one.
That is the Pelican Preserve Community Association's proposal
Okay,
for a memorandum of understanding. The other one is the most recent one. I guess, Bob, you handed out today again?
That's the same one I sent electronically.
And he also sent it out electronically. It's the most recent one that he sent.
okay, so we're going to be looking at these 2 versions only.
Those two versions. That is correct.
Thank you. So, Mr. Chairman, what is the difference between what Georgia originally sent us in our packets and what Bob just passed out?
May I, Phil?
Yeah, go
That's
ahead.
exactly why. Bill Strico for the Pelican Preserve Community Association. I'm not quite sure the protocol here. I don't know why Mr. Gephardt has standing to intervene between an agreement between the community association and the advisory group. But I understand his stature as a supervisor, so I'd be more than happy to address the differences as he suggested them. He's made a number of minor changes to the association's proposal. In paragraph 2 of the section under PPCA, he eliminates the phrase "as it sees fit." Curiously, he maintains the same phrase in the matched paragraph in the PPAC section. So essentially, he has said that the chair of the working group can address the advisory committee anytime they please, but the community association may not. Also in paragraph 2, he inserts the word that contact by the community association must be through the LWG chair, which would deny us the right to address you directly. I'm not quite sure I understand why that's necessary. Also in paragraph 2, he changed the word budget to the phrase the existing landscape vendors contract. The purpose of that clause was to allow us to address minor recurring cost items under $500 that were already covered under the budget. By inserting the words that Mr. Gephardt suggests, he essentially guts the whole paragraph because he makes the point of the whole paragraph is to address things that are not in the contract, that are over and above, that are recognized by the chair of the working group or by the community association. As something came up, a tree got hit by lightning. It's not in the contract. By inserting the words that Mr. Gephardt has inserted, we wouldn't be able to address that. In paragraph 3, he again adds the phrase the LWG chair as a filter between the community association and the advisory committee. It's not the way it works now. They use Scott as a budgeteer of the first order to require him to have to communicate to you through a third party. That doesn't make a lot of sense. And in paragraph 4, he changes the word formulate to discuss. So in other words, we couldn't come up with a recommendation between staff and the chair. We could only discuss between staff and the chair. I'm not quite sure I understand for that. In the PPAC session, in paragraph 5, he inserts the concept of a PPCA LWG rep in 2 places. No such animal exists, and the community association is not inclined to consider creating one. In the final paragraph, he adds the term the LWG shall. That I would think, given the representations we had made today by Mr. Perez, is absolutely outside of the ability of the working group to do that. So that that cannot be consistent with the sunshine law unless the group wants to have open notice meetings. That's what they need to do, but it doesn't fit within the burden of the paragraph of the agreement between us. Finally, he adds the concept of us doing away with the fee. We discussed that many
Doing away with
times.
what?
Doing away with the fee. Fee, I'm sorry. Fee. We discussed that many times. It just didn't seem appropriate to put it into an agreement between the association and the advisory committee. It's an issue between the association and the district. It is an element of the O&M agreement, has to be mutually negotiated. We're more than happy. We committed in public a lot of times, and we continue to stand by that commitment. We'll enter into those negotiations with counsel for the district or with the newly appointed contract manager for the district. That's not an issue. Just didn't seem appropriate to include it in an agreement that's strictly between you all and us. I think that covers all the changes. I'm not quite sure I understand some of the rationale for them. We think it'll work. I think Mark and Scott have been working together over the last month superbly. It's just the kind of collaboration we were looking for and cooperation. And this agreement pretty much codifies the way it works or can work and still stay inside the rules. So I just say this. We've been going at this now for 3 months, I guess, right? It's time to put an end to this. Let's get back to doing the business that we were all appointed to do and represent the people in our community. Let's get to work and put this formulary stuff behind us. Okay, thank you.
I personally am supportive of what Bill has said. I think that the agreement as put forth by the community association will allow us to work in the way that we want to work and within the rules that Tony has said as far as the sunshine laws are concerned. I don't see that, although some of Bob's additions are probably okay, but I don't see any need for them. I think our need is to accept the contract or the agreement as stated by the PPCA and move forward. So, because that will allow us to work in the way that we want to work. And I don't see any necessity to add anything else, my opinion. Mr. Gepper.
The fundamental document that was initially given to us, the one that Bill's referring to, I completely agree with. I love the agreement. I was very happy except for the exclusion of the money. But, and I'm still troubled by that most recent comment that it's up to negotiation. There's no negotiation. It's $46,000, period. That's what you told us you spend.
You said 41, 45.
I've never said anything other than 46.
I'm sorry.
Okay. I'm telling you, 46. Anyway, 46 is half the price. So why there's negotiation now, I don't know. One time we were told it's 70%. But the specifics of the change. Let's talk about the specifics. The changes were made because we wanted to make sure that we were totally in compliance with the sunshine. This is why I asked the attorney to go over the document. There were some small changes that I put in there myself, but the majority of them are recommendations of Tony. One of the reasons, since he brought up the comment of the change to the Ameriscape contract versus budgets, is in the Ameriscape contract, we have money for fixed price items. It's $539,000. And there's also money in there for non-contract type of things, where we're trimming trees and doing other stuff. There's more than enough money in the contract to do anything that we're doing related to landscape services that Scott has been doing for all these past years. All of the dollars, every nickel came off of Scott's budget. There's no changes in budgets. It's merely an effort to make sure that this is very clear to everyone and it can't be transparent or can't be, I don't want to be challenged further on down the road. I don't even know why we have the map for understanding, to be honest with you. I mean, the O&M will pretty much cover it because that's going to have to be amended. But specific to the document, it was an attempt at clarity so things wouldn't be challenged in the future. We could argue about a word here or there, but that's kind of minor. The intent is clear. And I do agree 100% that we are getting great cooperation between Castle and the group. What is totally new that just dropped out right now was that there's not going to be a PPCA rep or co-chair. They were demanding that early on, and now I hear they don't even want it. So that's new to me. I don't know if anybody else knows about that. So what I'm hearing is that Mark will be the sole chair of the landscape work group as a PPAC rep, but he'll have resources like Scott and the same thing that he has with staff over here to assist when needed. Now, did I get that wrong or is that correct?
That's wrong.
Okay. You do want to have a co-chair?
No, what's wrong is your representation that we were demanding it. It's actually your idea. That meeting between you.
Well, yeah, because you were excluded. That's where it came out.
And
I don't say demand, but it was at your initiation. Okay.
we don't care.
You don't want to have a co-chair. Okay, that's great. Then that
I don't
changes
think
all that.
Our understanding is we don't think we can stay inside the rules. But once we become part of the work group, now we're restrained by being a member of the working group. So
Can you please get closer to the mic so we can hear what's going on?
I don't think that's going to be an issue.
what I was saying, and I'm sorry for doing it from the floor, was that the reason why we dropped that provision, and it wasn't a demand of ours, we really didn't care one way or another. Actually, it was a suggestion of the supervisor that we were fine to go along with, was that, well, we thought that we would have some jurisdictional issues in terms of the Sunshine Law if we put a community association member on the working group as a co-chair, because now all of a sudden you've got two members of the working group coming together to make recommendations. We don't think we can do that because you need to have a notice meeting if you have two members of the group, right? So the whole idea of having a co-chair sort of fell apart as we started to look at the restrictions of the Sunshine Law. As far as the issue of the contract referral in that clause, what we're concerned about there is that it will restrict your ability to choose someone else to do the work. I mean, if you put that phrase in there, you're restricted to the existing contractor. You want that? I mean, if you want that, I'm fine with that. But it seems to me that I don't think you want to tie your hands. Anyway.
Yeah, the only thing we're restricted on contract, we share the same concern, is the 400 or 1,000 that goes to fixed price. There's no change on that. But everything else is subject to the landscape work group getting the best deal. Because they don't plan on automatically going to Ameriscape. They're going to put things out for bid.
This is where we have our structural problems. It isn't up to the landscape working group to go out and find the right bid. It's up to you guys. They can recommend to you that you go out and bid a contract. Well, you know,
The words are that the group has the opportunity to get outside.
that's why we're working on a written agreement. Supervisor alluded to the fact, why should we have a memorandum of agreement? Because we want to make sure the words are precise. We want to make sure the words are accurate. We want to make sure that we all have guidelines that we can work to and look at and feel in touch, rather than try to remember what we said. Okay. I do agree with one thing Bob said. Mark this down in the minutes, please. Yeah, I don't think we should dilly-dally over the words here. I think these words are sufficient the way they were submitted. I know that the community association will stand behind this agreement.
Mr. Chairman, the first one that was sent out with the agenda.
Yes.
Was this looked at by the attorney?
It was not looked at. Go ahead, Philip.
Let me try to make this clear to you from my perspective. Number one, Bill and I and the PPCA board, the association board, had no intent from the concept or from the inception of this thing to have a need for an MOU, for a memorandum of understanding. We believed that the O&M agreement was as clear as it needed to be for that purpose. When we first started down the road for this MOU, we came up with this concept, or you came up with this concept, that there was going to be a fee reduction, among other things. And we conceded on that simply on the basis that we wanted to move the agenda. But the predicate for the fee reduction was that a committee like LWG was actually going to do the physical work of operating the landscaping. And so in conjunction with removing the contractual amounts from the budget, which is simply a bill paying process, the LWG was actually going to do the work. In other words, they were going to take the responsibility away. They were going to interact directly with the vendors. And as a result of our informed information with regard to the Sunshine Law, that's no longer going to happen. In addition, this MOU puts a responsibility on the association to have additional meetings with the LWG chairman, which is fine, but you haven't reduced any of our workload. And the predicate that the fee was negotiated on was based on time on task. So my suggestion to you would be to approve the version that Mr. Sirocco presented to you, subject to final review by the district's attorney, call it a day. Because to try to negotiate the difference between Mr. Sirocco's, and mind you, we've been at this for 3 months, to try to differentiate the difference is inconsequential. I think everybody pretty much agrees to that. The fee issue is certainly at issue, but you haven't taken any work away from the association. Understand, we're all neighbors. We're all neighbors. Whether we pay this fee as part of our non-ad valorem tax or pay our fee as part of the association, that fee exists because those staff people are on board somewhere in the system. And they've got to be compensated either by the association or by the PPAC. My suggestion is approve the Sirocco version of this thing, subject to final review by the attorney, and move on with the agenda. Thank you.
Mr. Chair.
Yep. Mr. Stein.
I can't say that I'm the new kid on the block, so I'm the new senior on the block. I understand why there's an MOU, but I think it's a real shame that we have to have it. As you just got through saying, Phil, we all live there. We all should work together. We all want the best for the community. And so I take the common sense approach that let's do the work and let's not haggle over it. We've been at this since 2 o'clock and we haven't got much further than talking about this stuff. And we're not going to get through our entire agenda here for the rest of the day. And so we do need to move on. And I am really kind of interested in what Mark has to say, because Mark's going to be the chair of this person. And then what we do, let's just vote, let's move on.
Mr. Chairman?
Yeah, okay, Randy?
In the very opening of this, it says that PPCA will operate and maintain the district landscape systems and facilities. I would like to see specifically what constitutes a system and what constitutes a facility. And all it's going to add is a paragraph.
May I suggest to you that if we start to get into wordsmithing this document, we are going to be here forever and a day.
Yeah, but if
So
all due respect, Phil, if we don't specifically mention some of those things, then it becomes whatever the PPCA chooses it to be. It's not, if this is a PPCA and a CDD asset, then we need to know that. Are we talking the facility, the pump building? Are we talking the systems being the irrigation systems? I don't know. This is all question to me. Don't know what that means.
Sorry, I kind of agree with your approach. The words there, we picked right out of the contract between the community association and the district, which is the O&M agreement. Okay. They use a form of art. They call it facilities and systems. It's lawyerese, I apologize. But things like the irrigation part is a separate area. Ponds isn't a separate area. They all have their own definitions. So you can go to that basic contract and get the kind of definition, generalized definition you're looking for.
Thank
And
you, Bill.
we did that purposely. We use the
Thank you.
words,
Thank
we
you.
use the word.
I'm going to cut this debate off very soon. Go ahead, Bob.
Okay, very soon. This was another bombshell a few minutes ago. That now the community association is worried about reducing the workload. If I would recall to everybody here, first and foremost, we're only talking about GFCDD properties. We're not talking about anything that's a CD that they own. Secondly, they absolutely went nuts when we were going to put all the responsibilities on the work group and staff. The PPAC was totally committed to doing that, as was the landscape work group. The concession was that they felt they had to have an oar in the water. So they wanted to pay someone to watch a contractor do his work. Simplify. Why would we pay them to watch people that are under a contract to do work? That can be done by staff and by the landscape work group, and we'll do it within confines of the sunshine laws. But we kind of lost sight of that opportunity to save those monies, because now I think it's just enshrined that we must have Castle perform these services, and nothing could be further from the truth. We do not have to have them do it. We have demonstrated the capability through the PODS work group, and Alan, you missed these 4 months of conversations. I understand that. But the rest of the group has been here for all of them. And at one time, this group voted 5-0 to move these services to the district. Now, we've held that up and not presented it to the GFCDD to do it in trying to reach a negotiation. 2 main facets of the negotiation is we would honor their request to have Castle monitor for the community association at no cost to the district. Now, everything I've heard since the couple of communications where they said they would pay for it is they're now backing up. Now they want to look at time on task and all these other things. It will never be less than 46,000. Could be more. But now to say that they have to have the money because of the workload, well, we don't need them to do the work. Don't lose sight of that fact. It could be done internally, just like we've done POPs. And if the memo differences are so slight, why would you not take the one that Tony has offered? There's not some major changes in here. Is this just belligerence that because they wrote it, we got to accept it? You've got 2 documents in front of you. One that your attorney has looked at and one that came from them. Thank you.
Philip?
Philip Rogner, you got to be kidding me on this thing. Carol, when she came in, said that she had 5 different copies. We've been working on this and hammering back and forth on this, the 3 of us, or 4 of us, Phil Measy and Bob Geppert and Bill and I, for months. We have invited a meeting with Tony so that we could work out our common differences. That meeting was never convened on behalf of the association's participation. I realize that Tony represents the district and not the association, but we invited to bring our attorney to the table at our cost to be able to do that. This matter can be settled very simply. Approve the Sirocco version, subject to final approval by the district attorney, and call it a day. Bob has dismissed the amount of work that goes on with respect to the landscape contract. He thinks that all Scott does is watch them mow the grass and trim the trees. There's a lot more that's involved in this thing. And again, we did it on a time study based on actual work. And some of you were not on this committee, so you don't have, you've got a copy of that report, but you don't actually have it in this text that it was given. The only people that were on this committee that saw that report before were Mr. Geppert, Mr. Measy, and Mr. Greger. We are not looking to do something different. What Mr. Geppert is suggesting is you don't need the work at all. Well, that's simply not true. And if you believe that, then we will continue to have an additional burden on PPAC that the PPAC members, volunteers, simply aren't going to be able to execute over a period of time. So we agree with the changes in the agreement, We agree to take on the workload. The money piece is incidental to our total interest. Our total interest, we've got a $10 million contract at the association. You've got a contract, your budget here for PPAC is about 2.8 million. $40,000 is quite honestly chump change in this discussion. But you know what? If that had to be the concession to make it work, we'd agree to it. What I'm saying is it doesn't make sense. And I think that we had people in our last meeting who basically agreed with that. So have your discussion, make your vote. Let's move on with the meeting. Thank you.
Mr. Chairman, I move that we submit to the GSCDD the memorandum of understanding regarding GSCDD landscape services and facilities within Pelican Preserve between the Pelican Preserve Community Association and the Gateway Services Community Development District through its Pelican Preserve Advisory Committee. The version that was passed out by Mr. Gebhardt, striking the 5th paragraph under the Pelican Preserve Community Association. In other words, the paragraph that has the $46,000 in it. Strike that entire line. I've been going through and looking, that is my motion. I've been going through and looking, the words are so similar. And this was the version that Tony had approved. I don't want to come back to a meeting next month and have somebody say, okay, the attorney wants to revise this, and this. Let's take a vote on this again. Let's move forward. The paragraph, it's nearly word for word. And if Tony has seen that and already given his blessing to it, and you're sitting right there, Tony, so you have, correct?
As to the version that has the, handed out today by Mr. Gephardt, yes.
Yes.
Do you agree with the?
Strike. No, excuse me.
Bill,
I am making a motion, sir.
I apologize.
Striking the paragraph that need not be in there. This is an agreement to this is an addition, letter of understanding to the O&M agreement. I believe we have everything in here that you need. That is my motion.
Okay. Is there a second to that motion?
I'll second.
Mark seconds the motion. Is there any more discussion?
So in other words, this is going to be done without any concession relative to the cost. That $46,000 is going to go off.
That is correct.
But that can be discussed at a
That can
later
be
time.
discussed. That can be
That
discussed.
doesn't need to be a part of this memo.
Point of order, please, Mr. Easy. I'm sorry, Carol, for interrupting, but it appears as the council is going through it, he may not have seen all of it. So give him a moment, would you please?
Sure.
This is what you want to say.
Correct. That entire thing.
Yes, Mr. Chair.
Yes.
Does Mark have an opinion on it since he's going to be the chair?
Yes.
Okay,
Can you?
is that appropriate to listen to?
Yeah.
What, the second one that you're talking about, I guess a couple of the minor changes I had requested. And Bob put them. That was
Okay.
I'm just getting very tired of all of this as it's gone on for close to a year. And basically, I'm a resident of the community. I like plants. I understand a lot about them. And I've noticed deficiencies. My opinion is, don't complain about it if you're not willing to do something about it. A group got together. I agreed to be part of it. And now it's just turned into what you see today, which is people are going to start to argue about everything. I've been very relieved that Scott and I have been able to get together and actually make some progress, in my opinion. Ameriscape is actually starting to perform some work, which I think will help the community. And one way or another, I would like to just get this done so we can move forward and continue to make improvements on our community and just quit arguing about it.
All right, this is John Greger. Mark, what you're saying is you approve what she is striking out of that agreement that was brought forth.
I don't have a problem with it either way because we can negotiate that at a later time if we so choose. And if that's a sticking point, I would just as soon strike it for now so we can move forward.
Okay, so this has to do with Bob Geppert's proposal, but striking out that, and you second her motion.
Yeah, he seconded, so he's got to approve.
Correct. He seconded it.
Okay.
Yeah. Carol, recognizing your desire not to have this come back to the committee, if you will, I would suggest that we amend your motion to say that that particular version should be subject to further attorney review and approval by somebody on the committee. Myself or Mr. Evans.
So I'm confused as to what you just said.
I'm sorry, I didn't understand it either.
I'm saying to amend the Carol's motion to say that this version is subject to additional attorney review, since I'm being told now that the attorney did not completely review the version that was presented to us. Maybe become my amendment will become, yes.
If I could ask Mr. Rico to restate the question.
Oh, okay.
If I understand fully. Thank you.
Offline, I asked Tony whether he had seen the entire agreement as presented by Mr. Geppert, and I was particularly questioning the addition of the words the LWG shall in the paragraph that speaks to investigate all landscape easements. It's the next to last paragraph in Bob's version, the last paragraph in mine. I thought that mandate for the working group to act was problematical, and I would want to make sure that Tony had seen that. That was my question.
With the indulgence to the chairman, Mr. Gephardt, the staff, there have been so many versions flying around. I wanted to make sure that I'd seen. And this was provided to me by Mr. Gephardt. And in light of our conversation today, from the standpoint of having the LWG investigate, I think it's more appropriate the district engineer investigate all that, because that's really a function. And so with that modification, I think we'll have district staff will investigate all
the landscape easements.
Yeah,
In fact, that's who's doing it.
so that's your concern? By calling Bill?
Well, there were others. You were out of the room at the time. I think Carol is trying to move this along. And
Right.
I'm not going to stand in the way.
Oh, okay, well, I'm just curious what the other concern.
Okay.
Well, there were a number of Mr. Gephardt's changes that I thought were unnecessary, basically.
But not harmful, that's what I'm hearing.
The advocacy excluded in the first paragraph, I thought was harmful. That cuts down on the amount of. It cuts down on the communication and the collaboration. It makes it impossible for us to talk to you without Mark. We talked about the insertion of the also in the paragraph about having to go through the LWG chair before Scott could talk to you. It just isn't the way it works today when you do the budget process. Scott speaks to you directly as like an element of your staff. The change about budget rather than the existing contract, I think we've talked about a number of times. That could be a problem because what it says essentially is if there's any out of contract work that needs to be performed and it goes to a vendor other than Ameriscape, you destroy the ability for us to manage that element. So, I mean, I'm not quite sure why some of these changes are necessary. And if they are very minor and they don't otherwise affect the value of the agreement, I'm not so sure why we're spending a lot of time, as Alan has suggested. I mean, Carol, I would
So
suggest to you,
Bill, if we strike the paragraph about the 46,000.
Right.
Can you live with everything else?
You're saying no.
I'm saying that you can't live with it. It isn't even a matter of me. There are a couple of things in there that made it impossible for you to do what you're chartered to do. You can't pick a different vendor if you accept some of those words. I mean, this is up to you. If you want to handcuff yourself, you go right ahead. I tried to write this as even-handedly as possible, understanding that we were subject to your authority and the authority of the district. The district owns these resources. It ain't us. Our interest is that they look good and they're taken care of, right? Look, this whole McGillicuddy emanated from Mr. Gephardt. I'm just going to say this out loud because I got to say this. It's just been eating at me, right? He instigated this. He started this. Every time that Phil and I and Philip and even he have sat down and signed an agreement to put this to bed, he's found a way to resurrect the antagonism again and the discourse. I don't want to go through this anymore. I think it's time for us to get back to doing what the people elected you to do and elected us to do. Let's take care of the community. We believe this agreement does it. Let's stop the Mickey Mousing around. Accept it. I beg of you, accept our version subject to council review. And whatever Tony says at the end of that, we will accept. But I can't handle the politics of Mr. Gephardt trying to exercise his muscle all the time. It's driving me nuts.
Carol,
So it appears,
he would like you to.
reading between everything else, that the problem that Bill has is the shall in the very last paragraph.
No, there's more than that.
And the attorney,
There's more to it than that.
What?
Well, we've got a motion on the floor. I understand that you have a motion on the floor. And it is to accept Mr. Gephardt's version, but striking that one clause.
correct,
And that's what we're discussing here.
okay.
Mr.
If
Pierce?
I may, at the risk of
Yeah.
having something thrown at me. The part, anyway, the part with regards to the LW, as indicated in this conversation, the staff conversation we've had today about having, who's going to investigate the easements, that's going to be a district staff and engineer. So I think that's something that needs to be revised. That's something.
Okay.
And that's the last.
That's on page 4. It's the last paragraph on page 4.
And so, sir, how would you word that?
Well, again, they can decide what they want to charge themselves with. And so that's, again, it'd be a staff or engineer.
Okay, so, sir,
Yes, ma'am.
do we need that paragraph? The very last paragraph, the one you're talking
Well,
about.
it's up to the committee to decide whether it's
Yeah,
needed or
I
not.
don't think,
Excuse me, just
Is it even needed?
The only reason it's needed, Carol, is that it's come to our attention that we are providing services to lands that we don't have easements to, which is illegal. Tony told us to stop doing that. We can't maintain something we don't have an easement for if it's held by somebody else. So that's got to be addressed. I mean,
it's got to be
regardless of-
addressed, but does it have to be? in
But
this
that's what
agreement?
put it in here was just saying it was going to be done. And when we said LWG, it was never going to be anybody other than Tetra Tech. They're already working on it.
Okay, but excuse me, Bob,
Yeah.
may I have the answer from Tony? please?
Well, I just want to give you that back.
Tony, do we need this paragraph? Since staff is going to do it anyway, there's no reason to have this paragraph in this agreement, right?
If it's not in this agreement, I'm going to answer it indirectly in a sense. If it's not in this agreement, I think staff needs direction in order to expend the funds to engage in this activity, either through staff or through Tetra Tech. But it does need to be performed regardless.
But we can do that as a separate motion.
Correct.
Yes.
Yeah, so we could
Okay.
strike.
The key issue is, I think
Then let's
I think
strike
that-
this paragraph also.
the idea is to at least get something on record to move forward on this issue, to address it, so it's all up there in the open.
Okay, I have a question. Do we need this agreement at all compared to the previous O&M agreement? Do we have to have this to be in compliance with sunshine laws? Because nobody's conceded or done anything different that I can see.
My understanding, this is not relevant to the sunshine law per se. I mean, you have the parameters we've talked about with regards to the work group, how they would function, and an MOU may recite or outline in greater clarity the roles of the various parties. So we've already established what needs to be done from the standpoint of roles and functions in sunshine law.
Might I suggest that we can do without this MOU, at least today, that we can proceed with some of the things, other things we want to do. And then Carol, if you're willing to withdraw your motion, we just proceed without the MOU, do some of the things we need to do and determine what other things we may need to do in order to get things to work the way they want to. Right now, the way we're operating, at least with regard to the landscape work group, and the way Doug is proposing to operate with regard to the ponds work group, we can do it without having this memorandum. So my suggestion is that we withdraw the memo and we can all look at this in the quiet of our own homes with a big drink in our hands.
Mr. Chairman, I do not mind doing that. But we would still have the motion before the CDD that was passed many months ago.
Right.
And I thought that this was the method by which we were going to attach this and then the CDD would approve or not approve.
Mhm.
Are you saying you just want more time? Is that what you're saying?
I'm saying that we could use more time to work out the various things that need to be done without having this motion.
Phil, I'm a little confused. Something has been passed before by PPAC at a 5-0 vote and taken to the CDD. You now have another motion on the floor that has been seconded. And now you want it removed again? You're the only one, I believe, that has abstained with the first motion that passed 5-0.
But I think we've determined.
I mean, there is a motion on the floor. It has been seconded.
Tony?
If I may, again, and I generally don't like to interject myself from committee members or boards that are involved in the discussion on a motion, but after hearing the discussion today, I think it is appropriate to not take action on this today from the standpoint of having the staff go to the Board of Supervisors with a proposed clear resolution outlining the roles of the Pelican Preserve Advisory Committee, using this possibly as the template. And that's, we've had some discussions with manager while you all were discussing the other items. Because part of, I think, part of this confusion and cloudiness is not having that well defined. And I think that would serve everybody better. And we still have the outline, as you mentioned, that was approved by the board as to the functioning of the landscape work groups. That's still in place. So that's not going to change until the board changes it. And we've had conversations, I've had conversations with Chelsea and Laura was present. So what we would, I think it'd be a good course of action to withdraw that motion, not as considered today. We would work with the chairman to bring to the board of supervisors a proposal for a resolution clearly outlining the roles of the committee and the roles of the work group. And
Then,
believe me,
Mr. Chairman,
based upon everything that's been going on, we are not going to dilly-dally. Based upon everything we've the last few months, we will move forward with it with management. Carol?
I will table my motion until the next meeting, the next regular meeting.
Hey, Phil, you know how many meetings we've done the entire meeting on this? It bothers me that we're going to do it again at the next meeting.
That's not what I heard Tony proposing.
Okay,
That's not what I heard him
I'm
propose.
basically suggesting that this be tabled, and I'll call it indefinitely in essence, until the Board of Supervisors, who's the entity that established y'all, can obtain this input and craft a resolution to clearly outline the evolved parameters of the committee and the work. So that, and then we work on that. And I'm sure knowing how the Board of Supervisors respects this committee would have that, any draft resolution and parameters come back before this committee. So it's not a matter of stopping, it's a matter of changing the process and the method. So that's why we would recommend not acting on this today, tabling it.
hey,
Right.
Phil, the only other thing, I think if someone said that earlier, the group was working, Mark and Scott was working well together. We just had a thing where Scott and the landscape group and the ponds group worked together. And we didn't have a formal document that was all approved, but they worked perfect together.
That- What I was suggesting, Doug, that we don't need this motion today.
Okay.
That
Okay, and we continue to work like the groups are working together in cooperation.
And as a matter of fact, Mark and Scott are ready to make a presentation today of work that needs to be done so that we can get that started. And I don't think we need this memorandum.
All right, Mark, are you okay with this? An honest opinion.
Honest opinion, I'm tired of it all.
Yeah, but that's, I think everyone here is. But are you okay with it?
Going forward, working the way he currently is that right?
I don't think we're going to make any progress on this today, the way it keeps going back and forth. So in my opinion, we're probably wasting time today.
All right, what would you recommend then? Tell us, and I think that's what the committee would probably like to do.
I don't know what to tell you to recommend because like I said, I'm just trying to get some things done.
I would suggest we take Tony's recommendation, that Carol withdraw her motion, and we allow things to proceed, and we go to the board with Tony and what Tony has suggested. Carol, are you willing to withdraw your motion?
And what kind of timetable are you thinking of for this, Tony?
The board meets every 2 weeks. We have a couple of big items coming up.
Yeah,
As far as starting to work on it right away.
okay.
And then we'll try to expedite it for consideration. We
We don't-
recognize,
we-
we in the management recognize, especially Chelsea, recognize the need for expedited action.
I table my motion.
Okay, with
Is the seconder,
Is
will
it
the seconder agree?
are you agreeing with
Sure.
that, Mark?
Yes.
We don't need this motion to do some of the things we want to do. The things that Scott and Mark are going to recommend today, if we can get to it. We don't need this motion in order to do those things. We're going to leave this subject. I am mindful of the fact that we have to end this meeting by 4:30. My suggestion is that we amend the agenda to move directly to the landscape renovation plan, and that we schedule another meeting in order to look at the budget, to wrap up the budget.
And when would that meeting be?
That meeting would be in the next, I guess we can do it in a week. Well, we can't meet a week from today.
Can't meet on Thursday.
No, I know we can't, but let's say a week from tomorrow.
That's the
Which is Friday.
22nd.
Mhm.
I'm not available, okay.
But you can,
Whatever you want to do. I'm not available
yeah,
in
go
person
ahead,
that
Scott.
day.
Scott Charnock, Pelican Preserve Property Manager. If I may recommend, and if it's okay with Mark,
As you're aware, the committee has already approved $150,000 unassigned capital reserves to be used for landscaping. What Mark and I are currently working on is going to be using those funds on his design where he can present to you today so we do not lose momentum. To try to go through this plan and have a discussion in 20 minutes is really not good for all parties involved. If Mark is okay with this, I would rather Mark come up, give us his design plans, and we have the funding approved already, and we can come back and request the additional funding of $350,000 as I presented to all of you in the packet that I sent to you earlier. If that is okay with Mark, and okay with BPAC.
It's fine with me.
Okay, what 150,000 are you talking about?
The $150,000 to be earmarked for landscape renovation was approved by PPAC in 2021, and that money is still,
2021. Okay,
that money is still out there.
okay.
So Mark and I will not be delayed in our activities. We're still going to use those funds in the future, but they're available now to draw from.
Okay.
So we want to continue that. But as I mentioned in that detailed email and the plan, we're going to come back and request another $350,000 to complete the entire project.
But you will only present the first part today.
Yes, the design, well, a portion of the first,
Part.
yes. And Mark's going to present that, if that's okay with Mark.
That's fine. I'm just curious, you said the money is still out there. Where is it at?
It's in our capital reserve
In
funds.
the capital.
Yes.
Actually, yeah.
Thank you.
Okay, and
Were you going to set a different meeting date? Because I have the calendar up for when this room is available.
okay, when would it, I mean, we have to give a week's notice, is that right?
If you continue it, you do not.
Oh, okay,
At least that's how the board works. I assume it's the same.
okay. So when do you have space available?
What day would you, well, Friday, Thursday obviously is bad. Friday, we have something in here. Were you thinking of doing it at your same time or were you looking at a different time?
Well, we could do a different time. Do we have time before next Thursday or Friday?
Monday, Tuesday, or Wednesday are all available during the day.
Is Wednesday okay with everybody?
That'd be the
I have a
20th.
conflict almost every day next week.
You okay? No?
Mhm.
I'm okay.
I have a conflict on Wednesday.
On Wednesday, how about Tuesday?
I'm all right on Tuesday.
I can't do Tuesday,
Tuesday's okay.
You can't do Tuesday.
but I could do Wednesday.
How about, what does Friday look like?
Friday, we have something in here,
You do? But all day?
starting at 1.
Suppose we did it in the morning?
You would need to be out of here by noon at the latest.
Hmm?
You would need to be out of the room by noon at the latest.
Yeah.
Because we need to
If
get
had
set
it 10
up.
o'clock in the morning on a week from tomorrow, would that work for people?
A little earlier.
Even 9 o'clock in the
The
morning?
earliest you could come in is 9,
9 o'clock?
the 22nd.
Friday the 22nd.
So we're going to continue this meeting
Continue this
until
meeting.
next Friday, the 22nd at 9 o'clock.
9 o'clock.
Right, you cannot adjourn today. You have to continue it.
Continue, understood,
Yes.
understood. Okay.
And plus that still gives you at least a week to get the notice out there.
Mhm. Okay. And the meeting will be to continue what we're doing here, but with a focus on the budget.
Mark, did you want to present
Yeah,
your plan?
Mark, why don't you go ahead and
Right.
then we'll get a motion to continue the meeting.
Thank you.
Friday, the 22nd.
It shouldn't
at 9
take too
o'clock
long.
In the morning.
Everybody should have gotten in their packets on the board, 2 sheets that look like this. And basically, these are the roundabouts that exist over just outside of Prado Pistoia and Carina. And that's what the funds originally were designated for that were set aside that Scott was referring to.
What are on these roundabouts are Mexican petunia, which are considered an invasive species. There is oleander, which caterpillars and worms have done a number on. There's juniper. I mean, it's just a whole host of things. So what you've got here are proposals that I drew up. And I would like to put them out for bid through the CDD to see what kind of estimates we get on these. And then they would then be brought before the board to see which proposal we would like to go with. Okay. And so just take a look at them, basically leaving the existing large palms in the middle, removing the underbrush that exists all the way around those ponds, adding some sod to increase that barrier, and then putting in some different plants, which hopefully will do far better than what has been installed initially.
What do you
And you say this is gonna look good.
I think it will. I'm sorry.
Go ahead, Randy.
I'm kind of curious about what you use for criteria when you're making your selections. Almost everything in Florida is foreign to me.
Okay.
I'm from this part of the country.
The criteria I've used, for instance, some feature plants are false agave, which do very well down here. They give you the size, they give you coloration. The other one is using a bromeliad that gets large called Dean, which will perform in sunlight. It'll give you decent color. The other plants are plants that should take the sun. I've used dwarf white yesterday, today, tomorrow. They flower when the snowbirds are here. That's primarily where I like to use that one to get that biggest impact when the majority of people are here. Other ones, they'll stay smaller without a lot of trimming by Ameriscape, because Ameriscape is what they are. And I don't want to rely on them to take care of everything to a certain criteria. It basically has some flexibility with these plants. So again, I think they'll look good. I think they'll make the community look good. And it's just my recommendation at this time.
We have, if we start to go to the neighborhoods that are affected, we are going to be waiting months to get this thing done. We have certain ability because these are CDD infrastructure areas, and the CDD is the one that makes the decisions about how they'll be handled.
Well, actually, going forward from now on, since these meetings will have to be published before these designs can be finalized.
It should happen now. Because you have been following the guidelines that we went through.
Well, we need to move forward with these projects, I would suggest.
When he said if you let the contracts, you might have to renege on them if you didn't go through an open meetings process. From what I heard the attorney say today. Anyway, I'm just.
These are your recommendations, Mark, and not the recommendations of anyone else on the board.
Correct.
Yeah.
Correct. I selected the plants. I did ask people, give me some examples of plants that will stay this size with this kind of color. People gave me some ideas. I chose which ones went. So.
Yeah. These are things we need to move forward with this. We can't.
And again, going forward, we will have to have at least a monthly meeting where anybody can come in and give input on things like this. And I don't have a problem with that.
Okay.
So.
Any further comments from the members of the committee about Mark's proposal? I think it's worth adding that Scott continues to move forward with things that can be done from the current O&M budget. Scott, maybe you want to comment on that.
Scott Charnock, Pelican Preserve Property Manager. If any of you may have noticed, may not, we have been doing a lot of plant removal in the front of the community, and we'll continue that all the way down Pelican Preserve Boulevard to the four-way stop. The purpose is to remove the aged plant material and the plant material that will not survive with the dense canopy that the oaks are now providing down the boulevard. Some plants are going to be replaced. Other plant beds are not going to be replaced. There'll be pine straw. And then the annual flower beds are going to be enlarged and expanded in these areas for color. The LWG will go back later and we'll reassess with the group and get their input as far as what they visually see as a deficiency. And then Mark will make some recommendations for additional plant material if it is needed going forward. So noticed all of those areas are being funded through the current O&M agreement. It is outside the contract. It's within our budget and we've started the work. So there's sod work being done, there's plant and pine straw work being done. So you can see that. The plan is in play, it's working, and that's why I recommended that we just continue to use the funds that have been approved and revisit the entire plan at a later date. Thank you.
Scott, would you want to introduce the, your replacement?
Yes.
Can we wait on that?
We'll wait on
I'd
that.
like to clear
Okay.
what we're currently working on. Do we have a motion, Mark?
I guess I would motion that we approve the 2 designs that I put forward at this time.
Any further discussion?
For
on
a
it?
total amount of,
We're putting it out for bids.
oh,
at this point. I don't know.
so the recommendation is to put this plan out for bids.
Correct.
Right. Do we have any further discussion on that?
I'll second it.
And second, Carol, I'm sorry. Any further discussion? If not, all in favor, say aye.
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 Okay. Carries unanimously.
And I had one other part that I was hoping to bring up fairly quickly. Neighborhood HOAs are requesting to reduce some of their cul-de-sacs. Historically, this group has allocated just X amount of funds and to assist them, because technically we are responsible for those cul-de-sacs and their maintenance. So the neighborhoods of Portofino, Pistoia, Vincenza, and Catanzaro have all requested assistance with their cul-de-sacs. Historically, we've allocated, and I've talked to Scott and I've talked to other people, $1,500 was the amount that we would contribute toward that. Anything above that, the HOAs would find those funds. I guess maybe it's 2 parts, but I would like to get those funds approved for those HOAs. And again, in your concern, they are designing their own. They are saying, this is what we want to do, and we're just helping as far as the funding. And my only concern is 1,500 is a little light to really do much for landscaping in these cul-de-sacs now. And I was wondering if we could increase that amount to 2,000. A lot of these will exceed that. And again, the HOAs will come up with those additional funds themselves.
Are these funds already, do we have funds in the budget to do this, John?
It is part of our overall landscape plan and falls in line with that $150,000. So the funds are available. In the O&M agreement, no. So you can still fund it because it's part of the entire landscape renovation plan.
So are you making a motion?
I would make a motion that we allow these 4 HOAs to be allocated $2,000 up to a maximum of $2,000 each to renovate their cul-de-sacs.
I'll second that motion.
Do you have any further discussion?
How many other HOAs are out there that might come up and ask for the same?
32.
Yeah, now this, let's,
So we're not just talking about 4.
no, there's a lot of them, but quite truthfully, most of these are original, they're overgrown, they look horrible. We do have responsibility for them. So I think it's a good compromise that we contribute.
Now, originally, originally we used the term monuments because that applies to every single neighborhood where there's a limited number that have cul-de-sacs. So we didn't really address cul-de-sacs in my memory before.
Well, and there are neighborhoods, I happen to live in one of them, where we have already done the work. The money has been spent. It was our money. And there are places where people have, where some of the neighborhoods have actually done that. So in some cases it's been done. But Alan, to your question, I think we would have to evaluate as we go forward on each one. Any further discussion on this? If not, all in favor?
I,
Aye.
Okay, that's passed. So we are going to, I think that is sufficient for today.
well, I think we could do a few housekeeping things. For instance, Mr. Chairman, I would like to move to approve the minutes of June 9th, 2022.
Do I have a second? Approving the minutes of June 9th. Nobody will
I second.
Thank you, John. Any further discussion? All in favor?
Aye.
Aye.
That passes unanimously.
Mr. Chairman, I would like to introduce Nick to the group.
Yes, please, Scott, go ahead.
All of you received an email recently on the changes in our management structure. Nick is one of our Castle staff members who is relocating to the area, and he is going to take over the full-time oversight of the entire community. So Nick, come on up, say a few words. All of you have seen my emails. I'm going to take a support role, and I'll still be involved in Pelican. I'll still have office time at Pelican, but Nick's around.
Good afternoon, everyone. You've all read my bio. Again, my name's Nick Alianis. I'm with Castle Management. Been with Castle going on my 5th year. Prior to coming over to the coast, I ran Broward County and Miami-Dade County as a regional vice president. Lifestyle change in order is bringing me to the beautiful west coast of Florida. Our home will be done here in the next 60 days. We were supposed to be in today. So I've got a local rental and I'm here full time and very happy to be with everyone here on the West Coast. My background, I was in the Air Force for 20 years and 9 days in operations. And then I was in government contracting, running large government facilities around the world. Tried to retire again, play a little golf, rode my motorcycle and got a little bit bored. So I got into property management here in Florida, ran some very large individual properties, over 2,000 doors with food and beverage responsibilities, and many amenities, golf, everything, tennis, now pickleball, volleyball, everything you can think of, and enjoyed it very much. So this opportunity presented, I raised my hand high, and I hope I can bring some value to all of you here in the community.
Thank you, Nick. Anybody on the board have any questions of Nick? Welcome aboard.
Thank you.
We're glad to have you.
I have one question. Nick, is your office also going to be here at Pelican?
Yes, sir. It's going to be right across from Scott's.
Okay. John, that answer your question?
Yes.
Okay.
Thank you all.
One other housekeeping thing we may be able to take care of. The capital reserve study. Glenn had taken the lead on this and had started working on it. We need somebody else to take over that. And John, I am suggesting that you might be the appropriate person to do that, since you are involved in, you have been involved in a lot of the O&M and the materials we've got in the community. Would you be willing to take over the lead on the capital reserve study?
Can I could say yes, but right now I am remote. I'm not getting back down there until the end of September.
Well, my suggestion is one of the first things we need to do is start searching for somebody who can actually do the study. And I think you could do that from up there. My suggestion is, would you please consider that? And when we meet a week from tomorrow at 9 a.m., that we come back to you and ask you whether you're willing to take on that job.
All right, I'll consult with my friendly wife to see if she wants me to do that. She has to approve those special things.
And Mr. Chairman,
Yeah.
I noticed from the last community CA meeting that they are going to the company that had initially done their reserve study, and it's being revised based on the new construction and everything. I think that would be a place to start.
Yes, I think it would
Because
be.
that would be, I mean, they would know at least where Pelican Preserve is.
Yeah. And Mr. Sirico has suggested to me that there was work done in his community on a reserve study. That's another place, another potential resource.
Real quickly, and Philip can probably speak to this better than I can. What we're finding is that because of the change in the Florida law, that's requiring all the condominiums to have inspections and reserve studies done, that the industry is swamped. Unless you have a pre-existing relationship with someone, it's very difficult to get a new company to even return your phone call. So the earlier you start on this, I guess I'm suggesting, is the better. The community association went to that same company that I had recommended, and they said they call us back in 3 years, basically.
Okay. This is gonna take some work then. Okay. I would entertain a motion to continue this meeting.
You have to, I checked, it needs to be continued to a date and time certain, which would be Friday, July 22nd at 9:00 a.m. in this room at Gateway.
Carol, you had a.
Well, I was just going to say, I think we could look at the expense and asset analysis that Alan did.
You got 2 minutes.
We have.
Yeah, I got 2 minutes.
We have 2 minutes. I suggest we hold that.
Okay. I just want to say, Alan, it was a great job. I really liked the way you gave us percentages and stuff and didn't give us just line items after line item.
I would like to have that discussed.
Give them credit.
No, he did the work. I just gave him some feedback.
All right.
Well, you take feedback well. It was, I really like it.
Can I have a motion to continue this meeting at 9 o'clock on the 22nd of July? In this building.
So moved.
Is there a second? And moved and seconded. Any discussion? If not, all in favor?
Aye.
Aye.
The meeting is continued next Friday. We hope you can all make it.